It was a default that I never got a letter on. That has not been heard. I've sent letters to the judges. They have not responded to my letters. Saying, you guys, July 8th, I wasn't, it seems he sent the material to my ex-attorney in Portland, and it never made it to me. He knew I didn't have an attorney. They sent it apparently to Portland. That's what nearest I can tell. I never had it heard. There was no delivery.
What's the basis right now, sir?
It's because he's
Are you going to listen?
Yes, ma'am.
Okay, you're really having a problem with this.
It's because I'm emotional about what he's done to me over the years, ma'am.
Well, sir, I need
I'm
you
stripped
to
bare.
keep it in check. I understand you're emotional. I'm trying
they
to
have money, I don't.
Well, I'm trying to hear your emotions, okay? And so what I'm still trying to sort through is, other than the fact that you don't have a job anymore, why is it that you believe you can terminate your marital settlement
Let's go through it. The children are no longer children. They're adults now. They are no longer under any of my control. I did have partial guardianship. It's gone. There's no connection. There's no legal basis. There's not one material fact of that marital settlement agreement, of that contract, not one of the basis that's even close to what it was. If this were a business coming in trying to litigate a contract, you'd say, well, it's all business has all changed. You're no longer doing this, and these customers, these kids or whatever, they're not yours. There's not one aspect of that any longer that's true. The kids aren't mine. They're adults. I have no control and no contact over them. They've used process to take them away. There has to be the double edge where if they're going to do this, well, there's no connection anymore. We're separate parties. It's a dissolution.
Okay. I'm going to hear from Mr. Newton on this motion now.
Your Honor, there have been, Mr. Clark has previously filed a motion to set aside on 2 prior occasions and was represented by Randy Twing. The second time around, Judge Rasmussen heard extensive arguments by everyone, and it wasn't set aside. Now, the authority cites I don't see the relevance of the authority cites. It looks like it would be like a Rule 71, motion to set aside. But that's been done twice. All the issues were thoroughly aired, including the notion that it might violate public policy, which Mr. Twing was invited to submit a brief on if he wished to, and he decided not to. So there's nothing in here that relates to it's outside of a year, and you have to have any extraordinary circumstance setting thing aside past a year. It's been litigated. It's res judicata.
I see you, sir.
Yeah, and so there isn't anything alleged in here that has anything to do with the original judgment, which was effectively 2005. It was a really long time ago, and there's been multiple litigation about the provisions of the marital settlement agreement since.
Okay. Briefly, what would you like to say?
I'd like to say that this is an example of how he lies essentially to the court. Twang and Rasmussen and all that was within the first 1 year.
Let me just
That
tell
was a
you,
long
Mr.
time ago
Clark,
when the
even
situation was all
if I
different.
were to take you at your word that you didn't get mail about this life insurance issue,
Right.
which seems inconsistent with what I've seen in the file,
Okay.
there is no, this was an agreement that was entered into by you both, a contractual agreement. There is no basis for me to set it aside. This motion is denied.
Ma'am, I need to speak again.
No, your motion's denied. You
Okay,
didn't even
well,
ask
again,
for
I will
oral
appeal
argument. And that is your right if you wish to appeal it, sir.
I
You
will
also-
appeal that. And also, I'd like to say that you're not hearing what I'm saying.
I'm not agreeing with what you're saying, sir.
He brought up material from the year 2006 and used that as a basis. And I'm trying to tell you that in 6 years I have no condition that existed when the contract was written exists now, and that's not being heard. He went and
That's
just got
not
up
a
in court.
basis to set aside a contract,
It
sir.
is. It is, ma'am. Under contract law, if all the basics of the contract are different, the contract is then void or null. If a company has a contract and goes out of business, then it's something else. You have to then go deal with it elsewise. There's been a total change of all relevant circumstances since that was crafted.
I don't find a sufficient basis to set aside this contract, sir. And while I understand you have a difference
Appeal.
of...
I'm putting it on notice. Want to make sure it gets down. Appeal. Thank you. Sorry.
Do you need to get your jacket adjusted, sir?
No,
sir,
I'm
you're
hot,
very disheveled and you're
No,
very
excuse me,
emotional.
ma'am, I'm not disheveled. I object to that statement. I'd like to formally object to the fact that I'm disheveled. I'm hot.
I'm going to put on the record, your
I'm
hair
hot.
is disheveled. You are
I'm
unable
allowed to
to
have
follow.
my hair the way I want.
You are
ma'am.
unable to follow my directions, and I'm giving you a chance to get your coat situated.
I don't
since
want to
during
situate my coat, and I'm not disheveled, and my hair is fine.
Are you going to have trouble following directions?
I don't think so. It's
I
hard
think
to know
you
what the
are.
directions are. I don't understand, because what you're doing is you're taking everything he says and just accepting it. With
Actually, sir, I'm taking what you're saying,
No.
and there's no basis in your motions. I'm giving you an opportunity, just a second. I am giving you an opportunity to make oral argument. You have not complied with the rules to ask for that. These were not timely filed, yet I'm giving you an
These
opportunity.
weren't either. This weren't either. He just got done filing it all on me. I don't get it. I don't get why they can do whatever they want. I can't do anything. Okay.
When you're done, we can resume with these motions.
Resume.
The next motion is your motion to remand to agencies for investigation, kidnapping, corruption of federal process, organized, deliberate genocide.
Yes, ma'am.
Enter charges to court record against Bromley Newton LLP.
That's correct.
I have reviewed this motion. What would you like to say?
What I'd like to say is that I'm in federal process with a company, and they knew it. He deliberately took my assets, deliberately put me in the process knowing it. He's used the legal system to take away guardianship for no reason, essentially in conspiracy with it or in accordance with it. He knew I was in process. He knew it was destabilizing. He used the legal system to batter. And he used the legal system to try to degrade me even further. And that is genocide by definition. It needs to be looked at as such. It's been reported to the DA. It's been reported to the FBI. It's part of this because it's, again, part of his ongoing illegal, continued, massive criminal operation that you're ignoring, that I believe you're ignoring. I'm sorry, ma'am. You're not seeing the massivity of what he's done. Look at that file there. Have you ever seen such a pile? I've never argued with them. You guys, the money's there. They just take the money when they want. I never even try to hide it. They just take it. He brings up stuff from '06 saying, well, Randy Twang and Judge Rasmussen, well, I was making good money back then, Bruce. It's 2012 now. It's 2012. And he's saying, well, this has been litigated in 2006. He didn't tell you that. He didn't tell you that Twang and all that was 2006. I'm telling you, Your Honor, everything's changed. I have no job. They've taken all my money. Well, you know, this has been litigated in 2006 when I had a job and I had money.
I need you to calm down. You are having trouble.
I can't. I'm
You
sorry.
need to
I want to go home. I can't deal with this.
You filed this motion.
Wait, but again, they've pretexted the whole thing by filing a bunch of stuff late, making me think I'm in here to deal with compelling stuff, which we all thought.
You filed.
Well,
You're the one that brought this
continue
action
then.
to court.
Well, let's continue then. Let's go. Well, why wasn't it brought into court back in September when the thing with the kid was? Why did I have to wait 6 months for this hearing? I don't get that. He had it put off. He has too much control of the process. He's acted illegally on these garnishments. He's done all these little things wrong, and you're not seeing the massivity of what this man has done. He's taken an emotional, very spiteful, fragile ex-mother and systematically milked her to take control of funds. He's stolen $100,000 to produce a pile of nothing. It's never gone to court. There's never been a hearing since '06. Everything is settled outside of court. I keep telling him, Bruce, send me an email. What do you want from me? What do I get? A pile of legal papers I have to go deal with. It's just wrong. It's wrong. Each little piece of it might be right. That's the nature of genocide. When you have a structure that allows a person to be hauled out of their home, where then another side of the structure is allowed to take away their child and their money, that's genocide, by definition. It can't be denied. You don't wait for a pile of dead bodies. That was the Nuremberg directives. Holocaust is the structure of it. When a corporation gets involved in the removal of a child, or it's done concurrently concurrently with knowing genocide. It's by the Nuremberg definitions. Every bit of it. You cannot use the legal process to crush the humans systematically. You can't take each little part, like today's court and the other court, and life insurance, and go, well, you know, it's been litigated, it's been wrapped in a package. No, everything's changed. That's what I'm saying. You can't use Randy Twang in '06 and get up and say, well, this has been litigated, Your Honor. It hasn't been litigated, not under the facts of today. When it was litigated last, I was making $250,000 a year. If it was litigated, then I would have agreed. The judge would have said, well, you're making good money, Mr. Clark. Just pay your bills. Well, that's what was litigated. Now, I don't have a job. I'm in process. The mortgage industry's gone. There's nothing left to it. I'm 53. I beg a little money from my dad, and he takes that as some sign that I've got some asset. It's inhumane. Judge, Your Honor, I'm begging you as one human to another to look at the overall humanity and imagine waking up knowing you're having to come up with $5,500 after you've proven you've been hauled away in chains by SWAT on made-up stuff, posted it in the last week and given it all to the district attorney for his follow-up. It's so massive what's happened that it's not fitting well within the court structure, man. That's the problem. What's happened is so massive. I've suggested before this hearing that I have a very real case with Wells Fargo. It's very massive, and I've shown them it's simple. It's very simple because it's police audio video involved. I know what I'm doing with it. And they put it all the way through the process. And again, I had already filed FBI twice. Thursday of the week before, it was a short week last week, I put it back with FBI and District Attorney Alex Gardner. My advice to them was, let's work together. There's going to be some money out of this. Okay, I haven't started my litigation on it. Okay, I haven't gotten the attorney who goes and does the cleanup at the end of the wrongful process. My view is this whole thing's premature because I truly believe that if we work together, and again, did I not say this, you guys? Work together to say, look, we're a community. There could be some real big bucks out here. Why don't we work together on this? The different thing is about me is I've never hidden anything. I've never tried to, well, the Argentina thing in the first year was just that. It was a reaction. And then after that, I said, no, I can't do this. I'm right here. It's a long story what the human mind goes through. It's an emotional process, Your Honor. 3 months after a very long marriage, I was presented papers and I had no clue. And he says, yeah, they were litigated. Great. Okay, I understand. I swear to you guys, I do. But it doesn't make them the overall process right. You see, and so a child was removed, a guardianship. Again, I know it's a separate process. I realize it. But my way by the appeal process is and this is what I'm trying to get through to you guys, is that the way the process works is I have to put this stuff in to feed an appeal, which to me just seems so backwards. I don't like that. The whole concept of any of this litigation hurts me. And I've told them so many times there's nothing to litigate. The life insurance, I said, Bruce, I'm busy trying to get records, you guys. I'm old now, and they're making me give you 5 years of records.
What I'd like to do is now hear from Mr. Newton on this motion, because we have two more. I had hoped to get through the motions before we recessed for the lunch hour, but I fear that we're not going to. So I'd like to finish up this motion. We can take up the other two after lunch.
Your Honor, and maybe I'd like to be a little bit helpful to Mr. Clark in this regard. He said in this filing and many others that he was in federal process, and of course that doesn't have anything to do with what we're doing, and I'm not aware of the details about that federal litigation. I expect we'll probably hear some of it in testimony, but nothing that we've done has any connection to his litigation. And he apparently was arrested, and that had to do with Wells Fargo and his employment. Again, it's nothing to do with Ms. Clark or me. The SWAT people came or whatever. Again, we're not aware of any of those circumstances, and we have no connection to it whatsoever.
I see you, Mr. Clark. I just want to let you know I've seen you.
The part about the genocide, of course, I mean, I simply just don't understand what he's talking about at all. If Mr. Clark wants to dismiss this, the motion he has pending, of course we would talk to him about potentially modifying the amount of support, about what assets he does or doesn't have available given the things that have changed. But otherwise, I just ask you to deny it.
Okay. Mr. Clark, I saw you raising your hand while Mr. Newton was speaking. Is there something brief that you'd like to say in response?
It is related. He knew of the federal process when he garnished the money on August 11th. He knew of the process. Now, as an attorney, he should have taken a look and said, well, my God, there could be some federal obligations. He should have bowed to the federal process. He's also not considered or even asked for anything like, well, Andy, do you owe any taxes to anybody? Because obviously the federal government would have priority over money. So by him garnishing the money, and I would like to note that the garnishment didn't appear to be proper. I don't see a notarization. They just pushed it right through. Everybody just doesn't question anything. That's part of the problem. No one questions what's given to them. And so I'm working with Selco to see if this was a legal garnishment and that there's no notarized. They acted on an unnotarized, unofficiated document from what I can tell. It's here. I don't think they gave you that. Now,
It's not before the court today.
well, no, what it is, ma'am, is this. Why it is connected is because he should have, as it related to this, he garnished money related to this case. Okay, so that's the connection with this case. He knew I was in federal process. And there and then he should have said, well, no, I have to defer to the federal process. That's where I'm referring to corruption with the federal process. If you know a guy is in federal court, in district court, you really maybe ought to talk to the attorney on the other side and say, I don't know if I should be garnishing the money now. The federal government might have a claim on it. It's a common sense thing that I believe an attorney should have done is defer to the higher court when they know you're in court. He knew I was in court. Furthermore, he knew I was unemployed. It's unconscionable to take all of a person's money. It may be legal, but it's emotionally stressful. It's part of the systematic crushing and defaming that this procedure, this today is part of. So today we're at the tail end part of a genocidal action that involved the company making up a crime from zero, which I've completely documented, totally using their own audio video. It's unequivocal. We have the removal of a guardianship where absolutely no reason was given. All I asked for was a reason. She got up and said, well, he's dangerous. Well, how do you see he's dangerous? Well, back in 2006. It's the same thing. It's 2006. Both those two people seem frozen in the year 2006. Consistently. You heard it. Twang, Rasmussen, that was so long ago, you guys. What they're saying, it's all irrelevant. It is genocide because it's a process. You can't say it's not because this court isn't. You have to look at the process, and that's where they're not. They're not looking, well, we systematically beat him down over the years. We systematically dragged him into court and charged him every legal fee imaginable for anything. We knew he was out of a job and we knew he was in federal process, so we hit him anyway. We keep going. We keep going. For no reason given to poor Andy, the guy who's paying all this. And then you see, well, wait, this is being billed out at a couple $100s an hour. They've got presumably control of the trust funds. She had no idea what fees and what balances were in these funds that were supposedly for the kids. The fees on trust funds and investment accounts are very tricky. You have to see how the investments flow, the interest rates. You can easily steal from trust money that it's a large amount of trust money, last I heard.
Well, sir.
And it's all part and parcel. You can't, genocide is where you break up into little parts an overall ethnic action or against the retarded, and that's what's happened. This is part of the system. If you look at what we like to think of as genocide, say Germany, it was very boring until there were piles of bodies. You would have looked, well, we're all doing our job. That's what everybody said when it was over in Nuremberg. We all did our job.
Well,
we
what I
just
think
following
that you're
orders.
seeking from this motion, which is a motion that I can't see anywhere in Oregon law that this is provided for, but it seems like you really want to have some sort of charges brought.
Oh, absolutely. It's federal law.
And this is
There's
not
federal laws.
the proper forum in this case to do it in.
Right. Okay, great. We'll
So
put it
to
in the
that
right format.
extent, it's denied.
Great,
The
we'll
motion's
just put that
denied.
over on the appeal side too.
And with that, I'm gonna let you both know that what I see that we have left to take up before we get to this hearing, that for the record was initiated by Mr. Clark. We have a motion to remove opposing counsel, and we have a motion to sanction Bruce Newton and remand to agency. And so I will take those both up after, we come back.
One brief statement, ma'am.
Can
Very
you
brief.
be brief, sir?
This
Because it
briefest.
seems to be a
I was
challenge.
unaware that today's meeting was I was under the impression it was strictly the compel thing. And actually, he seemed to be aware of that too. That's one of my big problems. You're saying that I called the motion, the hearing. I know I called a hearing, but I thought this was on the compel thing. That's what I came prepared for. I had no idea this was on the modification. I want that to put on the record. And I think that I've given you a basis